Thank you. If I can resume the inquiry now. Apologies for the technical difficulties earlier and many thanks for working to resolve that. If I recall correctly, we were up to re-examination of Mr. Ross. Is that correct, Mr. Tucker? Thank you.
Mr. Ross, tragically, re-examination is not going to be very long after such a build-up. I'll deal with the last point first, and we'll deal with this in reverse order. The proposition that the rolling deficit on the trajectory won't dip below 100 units until the mid-2030s, has that ever been part of your case, that there's a need for it because of topping up the rolling trajectory?
No, it hasn't. It was a part of the context to the points I've made, but it's never been part of the case.
Thank you. You were asked questions in relation to two policies. I'll try the SS1 policy as the example, but it applies equally to the other. You were asked a question with a bit of a spin compared to the way in which we were discussing matters yesterday, so I'll ask it in the way it was put to you. You were asked a question about whether, if there was excess harm to the LLV over and above the allocation, would that result in a breach of the policy? And you said the issue is whether it conserves and enhances the LLV. Let me just see if I can understand your answer. If there was excess harm beyond that of the allocation, which was at the top end of the spectrum, a gross level of harm, could that breach SS1?
Breach criterion 14, and then a view would have to be taken on the policy as a whole, yes.
If there was excess harm at the trivial end of the spectrum, would that breach SS1?
No, it wouldn't. No, sorry.
Rotten at this game. Yeah, we're nearly finished. Firstly, whereabouts do you understand the level of harm that's said to be in excess of the allocation to be based on Mr. Williams' evidence?
Based on Mr. Williams' evidence, I understand that it's imperceptible both in terms of built coverage and density, in terms of the difference between the appeal scheme and what would be expected from the allocation.
So if that's right, is there a breach of SS1?
No.
Thank you. Next, can you turn to core document 4.6, please? The AMR. If you look at page 36, you were taken to a table. Do you recall that? I do. And we have the targets at the very top for each of the areas, and then we have the average between 2016 to 2023 at the bottom. The target at the top for sites adjacent to rural service centres and larger villages is said to be 30. Yes. So that's said to be the target in the AMR. What should we take from that? Yeah. And has that aspiration in fact been met? Thank you. Now this tells us about density. If you go a little further up, if you would please, to 312. 312. So I think you'll find on page 28. Yes. We know from the time of the adopted plan that the deficit by the end of the plan period was 279. Mindful of the fact that there's been an increase in density on those sites which have been consented, just have a quick look at that paragraph if you would please. Is the 279 deficit being whittled away? Is it steady or is it increasing? Has the deficit been reduced, increased, or maintained? So the fact that that's still a deficit, notwithstanding there's been increased density from the town centre sites, what, if anything, does that tell you about the town centre sites? And the larger villages sites, the fact that that's 28 against a target of 30, what does that tell you, if anything? Thank you. Next, if you would please, can you turn to HOU5? So you're in the local plan, core document 2.1. HOU5 appears on page 296. Take it from me, and I can lead on matters of record. The allocations start on 230 and go all the way to 282, with the appeal site being the last of the allocations. And you told the inspector that almost all of the allocations have their yield qualified by approximately.
Yes.
So let's bear that in mind. So of all the allocations, or most of the allocations, have their yields qualified by approximately. If you look at policy LPR HO5, to what extent does this apply to non-allocated sites, allocated sites, or allocated and non-allocated sites?
It applies to all sites as I read it. Yeah, irrespective of whether they're allocated or not, the general density, minimum density expectations set per location.
That's all right. And so, what is your understanding of the term subject to the overriding considerations? The following minimum densities are expected in the following locations. What do you say is the expectation of this policy if it applies to this site and other allocations?
The expectation is that the minimum densities here are exceeded. So the expectation in a larger village would be that a net density of 30 dwellings per hectare is exceeded where that's compatible with the individual settings of those sites.
You were taken to policy LPR SP7D, which is the neighbourhood areas policy, and the fact that 100 was identified for the neighbourhood areas policy, and my learner friend established with you that 100 doesn't necessarily mean that it's all made up of the allocation, and you agreed.
Yeah, SP10 deals. Yeah. I've got used to one way of doing it, and now I'm struggling. But they would take the view that the need in their area has been, the identified housing requirement, sorry, for the parish has been met through the allocation in the plan, the local plan. Therefore, there wouldn't be a requirement for additional sites to be allocated, and therefore any exceeding of the allocated number would need to be from the allocated site in the local plan in all likelihood.
So in relation to the figure of 100 for this neighbourhood plan area, is that understood to be a minimum, or is it understood to be a maximum, or just a target?
No, it's clearly a minimum.
I've had enough of the game of telephone tennis. Thank you very much indeed. Thank you, sir. Do you have any questions?
Thank you.
No, I have no questions. Thank you. Okay. So that being done with the evidence, now can we move on to a roundtable discussion of conditions? Thank you.
Just whilst that's been handed out, sir, there were two loose ends from the evidence, one of which I know that Mr. Ross knows the answer to, which I neglected to ask in chief, which is of the three options, what were the figures of those three options in the design and access statement? And the other was the brief, which I don't think we've yet seen, but if that can be sent over, that would be splendid before.
Yes, sir. So this related, excuse me, to the plans on page 24 of the design and access statement, CD 5.4. There were three options identified there as part of the initial part of the evolution of the project. And yeah, just to clarify, option 1 was for 100 homes. Option 2 and 3 were both 125 homes each, but in different ways, as you'll see from the plans.
Thank you. So looking at the conditions, I've just been handed two tables. I presume this one that starts off with a section highlighted of doctor surgery and self-custom build, that was the first version that was sent round. Okay. Thank you. So if I go through both documents essentially concurrently, if I look first at the conditions as proposed by the parties, essentially what I'd looked to do there in my comments was simply to replace them with the standard PINS model conditions as is preferred process for us to do. That essentially takes in 1, 2 and 3, replacing condition 1 there. And then jumping around slightly, of a condition 4 in respect of, I believe no one has any comments on those or complaint. So I'm coming up to height now. So yes, on the first 3 conditions, essentially where we've just gone with the PINS model conditions, what I've put in there. Any particular comments, complaints? No. And then the height limit, do you want to talk me through? I would say first the council, unfortunately. We've just lost our council officer. The particular need for this one in terms of defining the constant.
So our view on it is it's unnecessary because the parameter plan clearly states what the maximum height is on the plan and is an approved plan. Therefore, reserve matters couldn't exceed that height in any event, so it was unnecessary.
Looking at a copy of the parameters plan, and that essentially that's defined in the key, is that correct?
I believe it refers to 9.5 metres as the maximum height parameter on that plan and would be an approved plan.
So we don't take issue with what Mr. Henderson said, it's just how you achieve it, whether it's through the reference to the plan or in a separate condition. We don't think you need a separate condition.
It's actually on or not. The issue we have in terms of doing is, first, there is a necessity point from our perspective, but it goes further actually, because it also says nothing shall exceed 2 stories. So it not only deals with, it doesn't deal with height in meters, it deals with stories. And our parameter plan refers to the fact there may be occasional use of 2.5 story, for example, to create interest in a design sense. So I think it would need, if it was to stay on, I think it would need refining in any event. Yeah, if there's a necessity for it, that wording would be okay with us, yeah.
And then the reference to 9.5 metres is above existing ground level. As detailed on the plan, do we have those existing ground levels already defined? But there's another condition that's proposed that refers to levels as well, as they're not. No topographical plan is certainly not amongst the plans proposed to be included as the amended, as the approved plans anyway, which is only my thought, because then the question would be, well, what's the ground level if you haven't already defined what that is? And indeed the ground level may change, the existing ground level. Indeed a finishing ground level. Now I can't find that condition that I thought I'd seen previously. Yeah. Condition 11, no development shall take place until full details of the finished levels above Ordnance datum of the ground floors of proposed buildings in relation to existing ground levels has been submitted to and approved in writing by the local planning authority. Development should be carried out in accordance with the approved levels. Yes, quite.
Speak up. There is one of the plans that's just been drawn to my attention. Is the plan is dominated by the polytunnels in showing them, but there are levels marked on. It's plan reference. You might just scroll it down. It's CD 5.17. It's one of the existing plans. Yes, CD 5. Yeah, it's dominated by the polytunnels, so it's lights at the top of the structure. So those aren't the reference. When you zoom in, you've got a top underneath. So it's not without some information. Yeah, if you zoom in. Yes, there are. Yeah, there are. So when you zoom in on that plan, there are points throughout the site, not just round the edges. I assume so. We can I assume it's just a layer that could be removed. The polytunnels. Do you think?
So this plan isn't fit for purpose to be cross-referred to within the condition, but it's likely we could produce a plan by stripping off the upper layers from the CAD file to produce such a plan, which would be exactly the same as this, which could be cross-referred to, or the condition could be redrafted to require a topographical survey before commencement of development. So I wonder if that's one you could perhaps leave to the parties until next Tuesday.
Yes, or indeed bearing in mind that the likes of layout, scale and appearance are all being reserved matters here. So I wonder if even how far it is necessary, even if it does add clarity and an expectation for the parties. Fine, I think that is the solution then, that you can work together and produce that for next Tuesday. Yes, with the plan and the draft wording of that condition, can sort that.
We'll take instructions, I'm sure that will be if there's a difficulty, we'll report by next week. The other point is, of course, so you are right, you could take a view it wasn't necessary, but we're not pushing back against that.
Okay, thank you. So I'll take submissions of suggested wording and a plan on next Tuesday. Just to finish that one. Moving on to condition 5, I presume there's no comments on the proposed drawings. Those are the latest drawings. Those numbers are correct. Yes, thank you. Condition 6, yes. A phrase which I understand has been through the courts, general accordance, one which sets the hairs on the back of my neck off. General accordance. Like,
So this is one. I mean, Mr. Williams may want to speak to it. This was the one we weren't inviting you to necessarily add on at all, but in the event that you thought it was helpful, this was the point Mr. Williams dealt with in evidence, and I think mentioned that there could be a condition to achieve this, and that's the sort of manifestation of it.
Yes, sorry. So it's just if you needed that comfort, and it was particularly thinking about the internal landscape.
Or the council's thoughts on the need for that condition or otherwise. Then have condition 7, which is PIN's standard archaeological condition, and then the written scheme of investigation as a separate condition 8. Any particular comments on that? That's leading off from the conditions suggested by the parties. Then we move on to perhaps matters that people might get a bit more exercised about or interested in. Surface water drainage. Now, this is essentially against PIN's standard wording for it, essentially meant to be all-encompassing, which is substituted for the parties, perhaps sometimes more detailed, more selected condition. I'm happy to take comments on that because obviously it's of particular importance to the parties.
So the development that we have for 30 dwellings at Hawthorne Den, we have a problem where we thought at first that there was something wrong with the SUD system, but having had it looked at, it looks as if there's been some disturbance of the natural springs on the slope of the green sand ridge. Hawthorne Den is on the same similar level to the Kenward Road site, and it sits, as I say, on the slope of the green sand ridge. And we are having real problems in trying to get this sorted out because the road is all winter is underwater, and when it's really cold, it's a bus route, it's the route to the school, and it is absolutely solid with ice. And we have been trying for 4 years to sort this out, and nobody wants to take any responsibility for it. The developers blaming KCC, KCC are blaming Maidstone Borough Council, Maidstone Borough Council saying it's nothing to do with them, and we're going around in circles. And what we don't want to happen is something similar on this site, because it could. It's the same problem with the springs, and we just wondered if there was anything that could be put into the condition. I don't know how we do it, for the developer to at least look at the problem, if not take the responsibility.
Yeah, I think the highway's a problem, but also there are properties that certainly in Vicarage Road have been damaged by the water that's coming from the disturbed springs. And again, we don't want that to happen on Kenward Road.
Where in relation to the appeal site is this other development, just to be clear? the other development that had issues, whereabouts in relation to the appeal site is this development?
It's on Vicarage Road, which is the next road along, about half a mile.
Kenward,
They run concurrently across the high street.
Slope goes up.
And the development is on a similar position on the Greensands Way as the proposed development would be.
Concern being that you'd have a repeat of the same problem here, that you would get that. So the condition here, which I say is PIN standard condition, is quite a wide-ranging condition, which has benefits in terms it could catch all eventualities, but I suppose it lacks perhaps a specificity of some of the concerns that you have, and the risk, as ever, is if you're more specific, you also contain yourself as well as any of those details. But if you're sufficiently broad, you're asking for a detailed surface water drainage scheme for the site based on sustainable drainage principles, very broad principles but quite clear, based on an assessment of the hydrological and hydrogeological context, which would include things like the natural springs as well as just the nature of the site itself, context of the site, and that has to be submitted to approved in writing by the local planning authority, so the local planning authority would have control over that. If those details were not sufficient, if that assessment were not sufficient, you would pick it up at that point. Then going forwards, the condition also requires a timetable for its implementation, which could also be quite useful in terms of managing with the construction as well, but also for its management and maintenance plan for the lifetime of the development. So that would be taking control of that going forward, and you would have a very clear plan that had been signed off to ensure that that happened. And then its adoption would be by, as I say, public authority, statutory undertaker, or other arrangements, and those other arrangements can take on a wide variety of management company, or, as I say, get it adopted by the local authority. It's sufficiently broad that something's going to happen to it, but it doesn't tie down to exactly what it would be in the condition, given that that's not necessarily known at this stage. I don't know if the parties have any particular comments on that.
So, but obviously the ongoing monitoring will be caught by that condition in any event. So if my instructions are there is no spring on the site as a result of investigations, but one only knows about known unknowns, if you see what I mean. And that monitoring would pick that up, so there would be a condition and therefore an ability for the parish council, if nothing else was happening, to be able to go to the authority and say, hold on a second, these guys need to be doing this as part of their monitoring, as part of condition, whatever it is on the consent. So that scheme is really the way in for the parish council to ensure the authority enforce that monitoring and review process. I don't think the condition needs any further notice, any further amendment, but I think that's something to put on the parish council's radar for the future, given the existence of a past problem. Hope that's helpful.
Yes, and just looking at thinking of your wording there that you used in particular, I wonder whether or not it would be helpful to the parish to actually include under section 3 there to provide a monitoring, management and maintenance plan. So that would be an expectation. Does that alleviate many of the council's concerns? I appreciate it's not, you haven't got the detail in front of you now, but in terms of that matter being addressed.
Yes, I think so, because one of the problems we have with the existing site is there is no management company. The developer still has the responsibility, but they are about to pass it over to the residents who will form the management company. So there isn't a management, and the developer doesn't want to know. But yes, I think that's good. Thank you.
Thank you. Whilst we're on here, and excuse me as I just skip forward, there was also another proposed condition which I suspect would also come from the parish council's concerns regarding surface water coming onto the highway, the adopted highway as well, in terms of controlling that. And I'm going through to see what happened to that condition, as whether or not it was just removed, or because it would be my expectation that that would be taken account of in that assessment of the surface water management. Does that need a separate condition? Do the council have any view on that?
Yeah, we don't take issue with the addition of that condition, sir.
Thank you. And then we also had on surface water drainage a verification report as well. And that was essentially preventing occupation until a verification report pertaining to the surface water drainage system has been submitted and approved by the local planning authority. Is that belt and braces approach?
So that was just what the flood authority recommended.
Okay, trying to get myself back on track. Condition 10. Yep. So as the construction management plan, which again, as the PIN standard wording, I've omitted some that were irrelevant conditions and added in one particular point, which is point 2, about the routing of construction and delivery vehicles to and from the site, which I think was a particular concern of the parties. And I think I had actually omitted to add reference to temporary signage as well. Would that want to be included if the parties think that's relevant?
With regards to the temporary signage, I'm not sure that it's necessarily a condition, I don't know, but the last development that we had, because of its siting, the lorries were missing their turning. And Kenward Road is a very awkward turning for lorries. I'll probably have a look at it later. And I think there needs to be thought given to advanced signage as well as immediate signage.
Thank you. So I could amend point 2 to also include temporary details of temporary signage for the route, and that would solve that. Changing the wording on PIN standard conditions, I'll be drawn over the hot coals. Thank you. I will make a note of that. Okay. And then, yes, condition 11 was relating to floor levels, which is again more of the PIN standard conditions that talks about and includes a degree of flexibility in terms of ground levels And then coming back to sort of the 2.5 stories and 9 metres from ground level issue. Here covering off the landscape and ecological master plan, bearing in mind that landscaping itself is a reserved matter. Essentially substituting what was condition 11 out of that previous list, along with the standard wording for it. Any particular comments on that? It's less prescriptive, it doesn't have detail off.
Muttering to myself.
Then same for 13, any comments?
No, sir.
No, thank you. 14 for the biodiversity net gain monitoring. And again, 15 is just quite specific about the net gain uplift requirement. And that's a repetition under 16, so I don't think there's no difference between those two policies. No. The materials, I see the question whether or not that's simply reserved matter or not.
So for the council, we often at outline stage where we think it's important, we'll apply this condition and we will specify certain types of materials. So normally ragstone, timber boarding, and those sorts of materials that are reflective of the vernacular are those that we would try and put in there as an indicative palette that comes forward within the details.
In this instance, this could actually be left as reserved matter given that appearances.
So our position, so, is that a materials condition isn't necessary on the outline.
The previously proposed one, do we have the number for that one? I can't see it off the top. Yeah.
I didn't place the materials in the condition, so there's none to review in there at the moment, but it was if you were minded to, I would probably look to ask for certain materials to be specified.
Yeah. And
it's essentially to prevent, say, wholly rendered buildings where they may not be suitable for a context, for the local context. So you might choose a range of materials such as tile, roofing, clay tile roofing, or slate roofing, stock brickwork, or those are the sorts of things we tend to specify even at outline.
I think we're happy to leave it to you, sir. You have our point.
so the next one is essentially a tree protection plan. Are there any particular comments on that? Essentially substituting some of the earlier conditions. Fine. Thank you. Yes, 19 again was a boundary treatment one leading on for a policy that the parties, a condition the parties had suggested. Any particular comments on that?
but we'll leave it to you to take a view on ultimately. But we felt this is moving into reserve matters again in terms of the things that are being required additionally here through a condition that would be dealt with anyway.
Thank you. For renewables, I see I've got the policy justification for that. Thank you. Yeah, condition 21, referring to external lighting, was that essentially, if you like, street lighting, or was that lighting to people's homes? Like, 'cause I'm aware that would impact essentially upon what are permitted development rights, people have to put up their external lighting.
It was intended to be the site-wide lighting plan.
That's because that's the PINS policy, because PINS have picked up on that particular point before, whereas I think the earlier one hadn't done that. So again, the question is, would that just be covered off by reserve matter? I suppose the only concern is where and which one does that necessarily come under between appearance and layout and scale and all the rest. If there's no particular objection, it may as well stay or go. Okay, thank you.
Yalding is a dark village, and we have footway lighting, but not staggered. And on the 2 new developments that we have had, it's all low level lighting. There's no, and there are also, I think on the Glebe and Hawthorne Den, they have got restrictions on their outside lighting on their houses.
You say Yalding is a dark village. Is that a sort of official status or something you've sort of promoted? I know there's like dark sky areas, isn't there? And some councils are keen to get that point. Hey, I've seen Brian Cox and Stargazing live. It's the thing, and street lighting can hamper that. I remember being shouted at by a lady who wanted a cowl put up over her street light. So if it's a relevant thing and you've done it elsewhere, is it relevant to put that on here? And indeed, is that justification, bearing in mind the guidance and planning policy guidance as to why you would remove permitted development rights for external lighting?
It operates city pass.
Sensor operated.
And that is, I think, what you're referring to, because when you get those zone types, it sets out in certain zones you only have low-level light, etc. So you need to get into the detail to get that right.
Just wonder, sir, whether or not this is actually something that's sensible to have an outline in terms of a lighting plan, but it's too detailed for an outline stage, because one could have a lighting plan which doesn't then descend into requiring the layout plan with beam orientation, and that would be then provided at reserve matters. So the lighting plan outline might be, here's the sort of things that we would expect you to have. So in the common parts, you'd have movement controlled lighting, you'd have cowled street lights, etc. But it wouldn't go down to the precision of the precise location of where the lights are. So an outline permission style lighting plan, which has the expectation that you're then dealing with it at reserve matters. And the reason why I say that is that self-evidently you can't derogate from the grant of outline by your reserve matters. So if it's been restricted to that extent by outline, then it would be something to revisit in the detail that Mr. Williams rightly says at layout stage.
Two is a lighting strategy plan.
That's what I was looking.
So just for my conclusion, in terms of being a darker village, that's your impression of its character and its appearance, that it is a dark, low-lit village rather than a status that it's received. It is part of the character and appearance of the area. Okay.
Yes, particularly where the proposed site is in relation to the rest of the open countryside.
just looking at condition 22 now. Condition proposal by the appellant. Okay. Any particular concerns or comments on that? You obviously.
So it was a condition we drafted. We think it's important. I think it's just relevant to note because it secures open space provision, let's say the phasing, delivery and future management of the space, and importantly from the parish council's perspective, because they've raised this, and the policy requires it actually, the site allocation policy, that the design of that southern open space, there's a process needs to be gone through of which the parish council are part in doing it, and the condition secures that.
Sorry. I note it is open space strategy, but is there not open space on site A and we're referring to site B?
That's the intention, sir, and so it doesn't fall foul of the usual objection, which would be you can't impose upon a local authority who they should consult with for discharge of condition. It avoids that because it requires us to produce the open space strategy in collaboration with the parish council, and then for that to be approved by the council. So it sidesteps it quite neatly, frankly.
Yeah, the noise management plan, for one thing, operation of the development, I presume that would rather be occupation of the development, but I'm trying to think what the source of noise is beyond a domestic setting. Is a construction essentially?
Yeah.
I think that probably got caught up because I had chopped out and put in mine. Oh, one there. Thank you. Bonded surfaces. I presume it's a standard not wanting gravel or the like being able to get onto the highway. This is talking about accesses in site A and B. Is this not controlled somewhere else? Do we need a specific condition to deal with that? I'm expecting, I presume, the access to site, likely A and B, would they not be adopted? So they'd have to be an adoptable standard anyway?
This is something from the Highways Authority. I'm happy for it to be sort of merged with another construction management type condition, if that helps.
Yeah, I think it is necessary, sir, because it rightly deals with that initial point. It deals with access into the site, and self-evidently you can't adopt a highway until, I think it's either a year or 2 years, I forget which, after it's been completed anyway. So it makes sense to cover that to avoid getting mud on the highways.
Which ties up with the submitted plan and the plan that is detailed on that. Okay.
City displays. Displays, sorry. This is a question. I understand that the visibility displays into the actual site itself, but does the plan take into account those outside of the site? Because you're coming onto Kenward Road from the site, and you're saying, yes, we can see okay, left and right, but when you come along Kenward Road to join the high street, you can't see. And I was just wondering if there's anything taken into account to...
No, these are specific to securing visibility displays into and out of the site that are shown on the plan that's referenced there. It's not dealing with off-site issues that Kent County Council didn't take issue with.
Is it possible to look at that? Because the traffic that will be added due to the proposed site will significantly add to the number of vehicles that leave that point from Kenward Road onto the High Street.
I don't think there is now, if I'm being blunt about it. The highways evidence was presented to the inquiry as other responses from the consultees, and we've dealt with everything where was an issue raised with that. So I'm not sure it's something we could take on board now. Sorry.
Yeah. So if at some future date that became a problem, it would be KCC's problem. Yeah. Okay, thank you.
But to be clear, KCC have assessed what's necessary to accommodate this development and haven't concluded that there are works needed for that part of the public highway in order to accommodate this development. Had they done so, then there would have been works proposed within what's called a 278 agreement in relation to the context of this, and they haven't required that. But if there is a pre-existing problem, yes, it's KCC that the parish council needs to speak to.
Yes, because we have been commenting on this since the application first went in at 18. Is it section 18?
Thank you. I'll let you take that up with Kent County Council and the problems they've got there, or any problems they've got there. I don't see that I can do anything at this stage. Accessible and adaptive dwellings, condition 26 there. I haven't actually, if we get that, is it worthwhile getting that policy up there to go through the justification for this requirement? I see reference LPRQD6 as being the reason why been queried by the council, or by the appellant seeking, why are you seeking 100% accessible dwellings on this site? Sorry.
So the policy essentially is saying that unless there's any particular reasons why, this needs to be a requirement, and I haven't heard anything or seen anything that would suggest why this couldn't be accommodated. There's a suggestion as well in the comments about how a previous application hadn't included it, but that application had gone to committee maybe a year before and was in the process of section 106 being signed, so I don't think that was captured within that particular condition application.
So I think we don't read the policy in in the same way that it's been expressed there, that it's been expressed as a presumption that we have to rebut on it. It says development proposals will be considered having regard to site-specific factors, and what we haven't heard the council's position, and it does seem to be inconsistent with the example we've given that was only approved in May, where no M4-2 housing was required at all. And so we were just looking for justification for it based in terms of consistency of decision making, but also in terms of the policy. That was. Right. In fairness, we've asked for clarity on a few things, and we've not heard back from the council either. So I think I don't think it's fair to put the burden onto us as not having responded to something. We've raised a question that we haven't seen the answer to in terms of why no M42 housing was required on the scheme only a few months ago, but now it's a 100% requirement from this site, and we would just, if we could. But surely the local plan would have been carrying significant weight post the modifications prior to its adoption, so that would have applied at the committee stage as well as the decision issuing stage. So I don't understand that it was just ignored completely. Well, this is why we asked for clarity on the circumstances of that particular scheme to allow us to review it.
When the inspector asked for
So as I understand, even the points you're making there, that would suggest why they should have included such a requirement on that scheme. It doesn't necessarily say why they should not impose on this scheme other than they didn't on that one, that being your point. Thank you. And then looking specifically at the policy that talks about any particular issues, vulnerability to flooding, site topography, other circumstances which may make the specific site less suitable for compliant dwellings. Is there anything you want to highlight to me at this stage?
If at this stage all dwellings have to be M42, which is step-free access, without understanding the detailed drainage and topography, it can lead to problems because you've got the obvious drainage issues of having step-free access and not having a barrier. So I think that's why caution on all dwellings should be M42 should be applied at this stage.
And then the second part is whether or not it should be applied now or applied to a reserved matter. That's exactly the point.
You're not derogating from grant at this stage if there's a design justification to impose it at reserved matters, because the policy will be equally applicable now as then.
Any particular view on the council as to whether or not it should be or could not be applied at a reserved matter stage once you've looked at the appearance, scale, layout in particular, I'm thinking?
To give you a direct example, sir, if I may, we'll know then what the gradings of the roads are, so you'll then know, for example, what the effect is to topography, to be able to judge whether or not there are issues for particular dwellings. It's that sort of thing which will be apparent at that stage, which may not be apparent now.
I'm relaxed on that approach, I think.
Then moving on to water efficiency. Again, policy justification for that. So I'm just looking through again as the building regs M3 points. Any comments on that? There's no comments recorded on the table.
if it helps, so we're not pushing back on it. It's really whether or not it's covered by building regs or not. And that's maybe a point we can research over the weekend during a quiet moment. No objection at all to it. It's just double checking that point. So. Yes, sir, given the previous condition about bonded surface.
It's, I think the way it's phrased is acceptable to us because it's just explaining what reserve matters should include rather than requiring an additional submission, so we don't take issue with it.
I can provide you with one by email if that's okay. Yeah. Yeah.
Again, public art. I see. Is there policy justification for this scheme, and is that condition precise enough for the expectation of what's going to come forwards? I'll see what the appellant's already said on that. If you want to start, say your piece, and then we'll go to the council.
Probably can't add much, sir, to what we typed very briefly in there. I think we were just unclear as to the actual policy basis for asking for this, because as I understand it, there is no local plan policy relating to public art and no SPD relating to public art. There is some guidance from 2017, I believe, but it's not an SPD and isn't a development plan policy. So that was our question as to the rationale for it.
So we apply this on a number of major schemes, usually, and the guidance is reflected in the local plan, but it's not a policy.
Yeah, it's not an SPD looking at it, and it doesn't appear to be tied to any policy within any part of the adopted local plan.
On the H165, the KCC officer, sorry, on H165, the KCC officer came out to look at traffic calming and crossings. And he, on Vicarage Road, which is a comparable road to Kenward Road, he insisted on a scheme of urban quality, which meant that we would have streetlights to BS standards, zebra crossings, chicanes, and all sorts, and on sleeping policemen. And he was absolutely insistent that we should have this. He retired, and we had another officer who was appalled at it, and they have asked Countryside to put in a revised planning application to get rid of it all, the street lighting, and just have, get rid of the tabletop and just have a couple of narrowing, I don't know what you call them. And what I'm just asking is, when any scheme for traffic calming, pedestrian crossings or anything, before it goes to KCC, can we please be involved? Because we have got all the evidence from before, because again, it's totally out of keeping in a rural area. Thank you.
Can I say, I'm sure my clients who I know are listening will bear that very carefully in mind. I'm not sure you can weave this into a condition, because that would be a positive covenant, positive requirement in relation to a condition which deals with the requirement for a Section 278 agreement, which can only be entered into by the authority, by the county authority. So yes is the answer from my client's perspective. I'm sure I say that on instructions, because the WhatsApp hasn't lit up. But in relation to actually the condition, I'm not sure that the words would change. That said, the intention is that this is an informal pedestrian crossing. This will not be this will not be Blackpool illuminations in Yalding.
And the detailed plan doesn't include any of those humps and bumps and lights, so it should give you some reassurance.
The other point is the proposed walkway that's on the plan from Kenward Road to the High Street. As I said before, the land is in private ownership, but we do have an idea, because on one side of the road there's already a cutout with steps down the verge, and perhaps when we go on the site visit we can show you what we think we can do without causing too much problem.
It'd be worth us clarifying with you what you're referring to in an area, because the agreement we have here is for works within the highway, so it wouldn't involve anything with other landowners, and we couldn't get involved in, and there isn't a requirement to actually, based on the input from Kent today, to get involved in anything that requires anything with other landowners.
That's what happened is, if you read the it's a, I can't remember which drawing it's on, but it shows a footway, access on foot from the site through Oath Court and through to the High Street.
From us, yeah.
So, sorry, could I just add in something here? So, the pedestrian crossings is fine. I do want this to link to a 278 to include also the pedestrian footways, and I guess because that's part of the 278 surely, and that's an unknown at the moment.
It's within the site, not within the highway. Within the highway, they would have to be pursuant to a 278.
The discussion we've had previously is that the pedestrian route is not, fixed and sorted. So we need some assurances about where the pedestrian route is running. We've got the crossings. We don't have the pedestrian route running along the side. So I'm assuming some of that falls within the remit of the 278. That's just what I want clarity on, because you've got a route that runs from the site across the 2 crossings and then into the village.
The detailed access drawing shows where the highway boundary exists relative to those proposed footpaths, and a lot of them aren't in the highway boundary, so it would seem a stretch to have a condition on the outline based on a detailed plan where the footways aren't in the highway.
The condition and the specific things that are referred to there, the pedestrian crossing facilities on Kenward Road and or High Street, they were the issues raised by Kent County Council, and that's why they're specifically addressed in the condition.
So if I'm looking at this plan, the crossing we're talking about is the one at number 11, is that correct? Yeah. And there actually isn't one up by the main entrance there. There's a second crossing. Looking at this, the approved details, there's not another crossing up at the top. Just by the main entrance onto the site, there's no crossing here, it's just one. No crossing proposed there, but one proposed down here.
Yes, sorry. Yes.
Okay. But essentially, for the accessibility of the site, you are talking about using this footpath down here that comes within the other sites, within site B.
That's exactly right.
So my only one question is, how do people get from there to there?
Sorry. Yes, sorry. You can cross twice effectively. This was when there was discussion between the department and the council. Exactly the nature of these crossings. It was agreed to deal with the way condition and the subsequent section 278 agreement. We have seen by year you have to effectively cross from parcel A.
Yeah.
Parcel B, along the road, and then you cross again.
To get back to the footway network that already exists, you'll see on site how that works. So there would actually potentially be 2 crossings. The nature of those was under discussion, but it was decided it's best to effectively deal with that under a 278 agreement and agree exactly how you deal with those crossings, how informal or formal they need to be.
So logically, therefore, the condition needs greater specificity, because it should therefore refer to both the proposed pedestrian crossings rather than just the pedestrian crossing as using the definite article.
The proposed pedestrian or crossings, plural, and then you can.
I think it's fair points about the footway, because there may be some elements of footway where there would require to be some works, for example, where there's the tie between.
Yeah.
So that would be caught by facilities. So to be doubly sure, one could add words in brackets saying including footways. But I agree that should be pedestrian crossings, plural.
Including footways.
Where is the crossing on the High Street being currently proposed?
I'd need to find you a document reference to show, but it needs to be formalised through this subsequent process. But there is an indicative plan in one of the transportation documents. I'm happy to try and find it for you one way or another. I couldn't tell you off the top of my head, but I think it's in the transport assessment. Happy to try and find it for you.
Yeah. Sorry, the reason I ask that our concern about Ouse Court being used as a thoroughfare, the plans that we looked at, the crossing was at the entrance to Ouse Court off the highway. But it's not a thoroughfare. But it is. But people naturally take that route, even though it's not a legal thoroughfare. We can point it out on this.
Wonderful. Not to kick the ball back into your court, but would you like to come back to me with amended wording for condition 34 on Tuesday? Thank you. Contaminated land, again, that's the planning inspectorate standard setup for it. And again, soft landscaping, you say not relevant at this stage because you've got the landscaping reserve matters. The council happy with that? Which is 36. Yeah. The protected species and like, is that necessary? Everyone happy with that one in? Yep, thank you. And the tree protection measures, which does that not leave us with 2 tree protection measures? Yep. Okay. Thank you. And then lastly, it's again 39 agricultural method statement. The trees, any comments on that? No. And 40, any particular comments? Trees, hedges on Kenward Road? No. Fine, thank you. And then I've got a note here at the bottom. Okay, yes, this the potential for any damage related to development.
Something you were considering pursuing, and we expressed our concern over how you would create this condition and enforce it one way or another. So I don't know if it's something the council intends to still continue with, or whether it's drop that.
It's a KCC point. I did ask for further wording today to see whether I didn't ask today. I asked a couple of weeks back for a response, and I actually got one today. So if you could just bear with me.
Was just that it would be, for a scheme of such a small scale in relative terms, and in this, it would be almost impossible to work out what damage was, if any, was caused by construction traffic in a short period of time versus existing agricultural traffic that already uses the road one way or another. And I don't know how you'd determine that and then enforce it one way or another.
So having looked at the highways response I've received, it's the same wording, and they've said that's the condition. So
Sorry, can I just... It might be that Townbridge regularly gets hit and KCC are regularly repairing it, and they seek to get the compensation from whichever lorry hit it. So it is a regular occurrence, and I'm guessing that's why they've...
And Kenward Road. But, well, there is the problem of lorries turning in and out of Kenward Road, and the times when they end up damaging the village green and the grass verge, or knocking the walnut tree wall down. But when you come to prepare your construction management plan, the lorries are probably going to have to come over Townbridge, because the route from the north coming down the hill is too narrow for large lorries. And that is where the problem can happen from drivers who don't know and understand the bridge. And that could happen with the construction lorries.
But as you say, the construction management plan has a clause in it for a route to be agreed and the like, so that would be perhaps, hopefully, at least help alleviate that matter.
Well, I think it's worded, it's not specific to the bridge. I don't. But it may not be via the bridge.
You could almost apply that to the entire of Kent. Or you could be more reasonable and say, well, actually, it's far more localised than that, and I think as it stands, it needs to be more precise than that. I need to know exactly what it wants to do, whether or not Kent County Council Highways are going to come back to you with something more specific than that. I'm not keen to kick everything down the road until Tuesday, but I will take written submission on that for Tuesday if we want to raise that then and see what proposal they would have to deal with that.
Yeah. I'll try and close it down tomorrow. Yeah. Yeah. Is there anything else?
Could we just ask?
That's me.
Oh, thanks. Could we just, I'm sorry if this is the wrong place, it's just that with H165 we have a real problem with parking because the covenants in the deeds of the properties say there should be no curbside parking, and Countryside have appointed a management company who are enforcing this, and therefore it's pushing vehicles out onto Vicarage Road. And our concern is that we can't, it's pushing it from Vicarage Road into the High Street and some of it onto Kenward. And we're conscious that if it happens again, we're going to be absolutely saturated. And I don't know whether you have any plans to do something similar, or whether there's something you can regulate that makes sure that the parking isn't pushed off, it's on the site.
Yeah, so if it helps, yeah, I think it's a reserve matters point because parking will be dealt with through reserve matters. Obviously, you'll be as parish council consultees on the reserve matters. Well, absolutely note your concern in that sense, and I'm sure my clients will as well, and whoever builds the houses will also. But you'll have an input, as will the council, to make sure that parking isn't happening on the road and sufficient parking is provided within the site.
If not here, is it possible to have a condition that the developer can't impose a covenant that they will enforce parking? because they actually have parking enforcement and do enforce it.
Yeah, I mean that's not something that you could certainly do at outline. I'm dubious you could even do it at reserved matters. It's really a matter of private law issues and the consequence of parking on street. I suspect it may be something because of the parking levels which are consented on the countryside scheme not being adequate and then requiring to keep roads clear of vehicles. So it's a matter to pick up at reserved matters to make sure there's sufficient car parking and sufficient visitor car parking. Can I give confidence? I'm an advocate. I can't give any confidence to anybody. Mr. Williams may be able to say whether or not that will provide confidence as to whether parking's been taken into account in the design.
I think there's two parts to the answer, which is a merger of both points. That the on-street car parking is identified in the approved highway plan for Kenward Road, and the parking within the site would come through the reserve matters process, which you would consult on as a parish, and the authority would ensure that the quantum required for each unit is provided for on site. So it's both of those answers squished together.
I think our concern wasn't necessarily the quantity, although that has an influence. It is the enforcement issue and the non-commercial vehicles issue, that the development looks lovely, but our roads don't, because commercial vehicles and other properties being pushed out, and it's probably our biggest problem, probably bigger than traffic at the moment.
It's not uncommon for that to be a condition on the reserve matters when you can see exactly what the configuration is. Yeah.
Thank you. That draws an end to those list of conditions that we've run through. We haven't gone through the section 106, but I notice I've got the addendum statement of common ground between the parties that essentially agrees that that section 106, albeit in draft form, does answer the remaining concerns of the council in terms of the putative reason for refusal 3, 4 and 5. So I don't feel I need to go into that now unless you want to tell me any different.
So, I mean, the big point is the point you answered this morning, which was whether you had any particular points that we need to pick up in drafting terms. And if you don't, then more than happy to proceed on the basis of the 106.
I'm quite happy with that. Is there likely to be any issues getting it signed and executed appropriately?
Sorry. With regard to Site B and turning it from a fallow field into an amenity area, I assume there's nothing in, we haven't seen the section 106.
I've just got it.
Oh, you've just got it. Would there be funding coming through to do that?
There's nothing in the section 106 about the open space, so you've not missed anything in that sense. It's dealt with the condition we talked about before, which deals with all of that, including future maintenance to be agreed, and the parish council are specifically identified as being part of that process for parcel B.
That's the one that's drafted in collaboration with the parish council.
Yes, and so turning to your practicality question, no, there's no issue in signing it. Our client owns the site. It's actually, so there's one signature required effectively in this instance. The only issue, but cut a long story short, we've been asked to suggest that if you were able to give us 2 weeks to get it completed, it's more to do with the fact that the council, as I understand it, only has a signing day once a week, and if we miss that in week 1, it would take another week. So if we could have 2 weeks afterwards, that should be plenty.
I understand that 2 weeks is fine from that perspective. There's one additional point on this. You asked for the statement of common ground. It's been drafted, it's been agreed, and it's coming off the printer now. So that's where Mr. Scott has just disappeared to.
That can be brought on site shortly, sir, in a signed form.
we're not. It's not all of us coming.
Sorry. Thank you. There's no discussion out on site because I can't take notes, so I'll adjourn the hearing here, inquiry here. Don't let me close it here. And then it's simply not an opportunity for me to go out on site and see the sites. There won't be a discussion on site. If you want to point out particular features or aspects you want me to take note of, I can do that, but there won't be a discussion on site because it's too difficult for me to take notes, and not everyone from the parties will be present. I had a brief itinerary from the parties, so I can see the immediate area around High Street, Midway, and then further afield as well, which I'd like to try to take those in as well. I have seen some of the sites already, but if we can tick those off as we go around as well, that would be helpful. Thank you. How are we for time? Is there going to have any time pressures in terms of leaving at the end of the site visit? Not for me. 40 minutes, yeah. And I would have someone from each side. Okay. Thank you.
Housekeeping point, sir, if that's okay for the council, principally in terms of Tuesday, and just make sure we've got the relevance of calendar invite, Teams invite, the logistics effectively for Tuesday, so people can access that virtual session, including the main parties this time.
And so you already have, I think, our apology that I won't be in attendance next week. Mr. Carter will be stepping forward, so you won't hear the monkey, you'll hear the organ grinder.
Thank you. So we're doing it, the proposal is to do it online, which the requirement to set it all up falls as ever onto the council to organise that. If that can be sent round in an email to the parties, meeting invitation, and also details of how members of the public who may wish to observe can be put online as well. And exchanging your closings, if you can do that, since you just moments before you do actually present them. And the way I found it works best, if you actually exchange them between yourselves, copying my case officer into it, it means you get them immediately, and hopefully it falls to me before you get into your stride. Thank you. Thank you. I will adjourn then until 10 o'clock on Tuesday online. Thank you.